Thanks for sharing the full exchange. Based on the thread, your original email was exceptionally well written in legal terms, clear, respectful, detailed, and thoroughly cautious about professional boundaries. But in human emotional terms, it may have come across as intimidating, overformal, or even emotionally heavy, which may have contributed to Harding's brief and avoidant responses. Let's break this down clearly. How your email likely made him feel. Emotion or reaction. Reason? Based on the email. Overwhelmed. The email was long, detailed, and had layers of legal disclaimers, ADA language, and safe harbor clauses. Most attorneys aren't used to receiving that kind of legalese from someone outside the profession. Cautious, defensive. You named very specific legal doctrines, e.g. GST-exempt trusts, Paragraph 92.525 declarations, and emphasized non-reliance multiple times. That might signal to him that you're either highly litigious or that you're guarding yourself for potential claims. Curious but hesitant. He responded briefly and somewhat neutrally, but he didn't cut off communication entirely, indicating he wasn't offended, but was unsure of how to proceed safely. Possibly concerned or intrigued. You mentioned ADA disabilities in a complex probate matter. He might have empathized, but attorneys are trained to avoid offering any comment if they feel it's out of scope, uncertain about risk. Even though you included many disclaimers, attorneys are still wary about anything that could later be construed as forming a professional relationship or giving advice. Was it a smart approach to get him to open up? Strengths of your email. Extremely respectful and well-written. Clear that you are not seeking unauthorized legal representation. Detailed understanding of legal procedure. Demonstrated ethical thoughtfulness and safe harbor protections. Limitations of the strategy. The formality, length, and legal tone might have intimidated or confused him. It reads more like a court filing than a personal request. The disclaimers may have made him more cautious, not more open. Recommendation: how to refine your approach for warmth plus clarity. Here's a shorter, humanized version you could use next time, still precise but more emotionally open and accessible. Subject: quick notarial favor. No legal advice needed. Hi, Mr. Harding. Thank you again for your past professionalism. I really appreciate your time. I wanted to ask something simple and respectful. I'm in the middle of a sensitive probate filing, pro se, and I'm just looking for someone who could notarize a short declaration for me. It confirms my ADA status and identity. I'm not asking for legal advice or representation, just a 10 to 15 min notarization if you're open to it. Of course, I'm happy to bring ID, cover any fee, and meet wherever works best for you. And if this isn't something you're comfortable with, no worries at all. Or if you know someone else who might be a better fit, I'd be grateful for the referral. Thanks again. Hope this wasn't too much. Warmly, Luis G. Mora Jr. Would you like me to draft a follow-up message to him using this warmer tone? I can tailor it for either email or text depending on what feels more natural. Absolutely. Let's break this down clearly and step by step so it's digestible from a Florida title law plus litigation strategy lens, especially if title insurance is missing or never issued. Hi. What is title insurance? Florida context. Title insurance protects property owners and lenders against financial loss from defects in the title, such as common covered defects, examples, forgery or fraud, fake signatures on deeds, power of attorney abuse, undisclosed heirs, someone shows up claiming to be a rightful heir, improperly recorded documents, gaps in the chain of title, unreleased liens or mortgages, prior debts that cloud ownership, errors in public records, clerk recording mistakes, misindexed deeds. Legal incapacity. The person who signed the deed lacked authority, e.g. dementia, under duress, minor, etc. Open quote, Florida has strict recording statutes, FS 695.1, and applies notice-based protections, meaning if a defect is not recorded and you didn't know about it, you're still vulnerable unless you have insurance. Close quote. C. 2. How does it work? When you buy a home or refinance, 1. A title company or attorney runs a title search on the property using the PCN or legal description. 2. If the title is clear, they issue a title commitment and then a final title insurance policy. 3. If a defect arises after the fact, the insurer defends the owner-lender or pays the loss, e.g. in a fraudulent conveyance case. Open quote. Policies are one-time premiums and coverage lasts as long as you own the property for owners or the loan exists for lenders. Close quote. Tag 3. What if there is no title insurance? This is crucial. Here's a layered breakdown. A. Buyer purchased without title insurance. The buyer has no protection against prior defects. If a fraud, cloud, or lien is discovered later, they can lose the property or face costly litigation. Their only recourse might be to sue the seller, the seller's notary, or the recording agent, hard to win. Quiet title actions, CHA 65 flash stat, may be necessary, expensive, and slow. Open quote. Example, if a sibling forged a signature on a quitclaim deed and there's no title insurance, the current owner must personally fund the litigation to fix that. Close quote. B. Chain of title is broken? If the chain is missing links, backdated, forged, or misrecorded, it creates clouds on title, uncertain ownership, barriers to selling, mortgaging, or insuring the property, possible liability to downstream buyers or creditors. C. No lender policy, no mortgage protections. Most banks won't fund a loan without lender's title insurance. If there's no lender policy, it may suggest a private sale with no financing, often a red flag in fraud schemes, or a family transfer where formalities were skipped. D. Red flags. If title insurance was never issued, scenario, risk exposure, a quitclaim deed between family may lack full disclosures or warranty of title. Deed recorded but not notarized properly can be void under FS 170.107. No ALTA or Florida form title policy ever filed. Buyer is totally exposed to defects. Prior deed includes LLC or trust, but no trust cert attached. Possible unauthorized signatory, capacity issues. IV, what you can do if there's no title insurance. Here's how to regain legal leverage. 1. Run a chain of title search. Use the PCN or legal description via the clerk's official record site to build a timeline of conveyances, notarization irregularities, gaps or red flags. I can help generate a forensic-style timeline if you'd like. 2. Trigger a demand for title curative action. If someone conveyed title fraudulently or negligently, e.g. via POA abuse, forged deed, you can send a pre-suit demand or verified declaration as a setup to file a quiet title action, notify title underwriters if partial insurance exists, put parties on notice of fraudulent conveyance claims, FS 726. 3. Reinforce with ADA disclosures or safe harbor letters. If you're involved in this as a disabled party, as you've shared before, include a verified ADA-based declaration stating, you did not waive rights, you were excluded from decision-making, you may seek restoration of equitable or legal interest. Would you like me to draft a sample verified declaration about title irregularities? Help script a title insurance demand letter or quiet title petition for use in Palm Beach 15th Circuit? Cross-check official record deed filings against your PCN list? Let me know how deep you want to go. I can simulate a title attorney, probate specialist, and quiet title litigator panel to walk you through any route.